Good morning, Coldwell Banker George Realty. Thank you for attending this very important training session. We kind of pulled this up to the top of our training because with all the wildfires that have been in the area, there's probably going to be more leasing opportunity. And today I'm going to go over the lease agreement. However, we're going to have a discussion on how to handle applicants, what to say, what not to say. Peter Cam is here to advise. So I'll get started with the lease agreement, but please stay till through the discussion because the main point of this is we want to prepare you on how to handle applicants and what to do in those situations when you're talking to them. Okay, so even if this lease agreement is less than a year or just at a year, there's a portion in the lease that says that you do not have to have an agency disclosure. Our brokerage requires it. We want the agency disclosure on your lease agreements. If you're not the listing agent or typing the lease agreement, you still should have had an agency when you filled out the tenant broker representation for compensation. So please make sure that you always have an agency disclosure when you are rolling with clients. Okay, so I'm not going to go over this because that's pretty standard for us. And the CCPA does populate on the lease agreement. There's other disclosures, but today I'm going to focus on the terms of the lease agreement. So this is the residential lease or month-to-month agreement. So date prepared goes here, tenant, and we need to get used to saying rental property owner or RPO goes here, the name of the RPO. So the housing provider rents to the tenants in the property. You put the address here of the premises on A, and B is really important. So B outlines who has the personal use of the personal residence. So let's say it's Mickey Mouse and Donald Duck and 2 minor children. You can note that, the 2 names and 2 minor children, unless that, well, I won't call them a child, unless they're 18, then they don't need to be named here. You put minor children. Some people, you know, I don't name their children. I will put minor children. So, and why is that important? Because any person, if you look right under B, in the premises other than these listed in B, are considered guests. And there are 14 days that they can stay without the housing provider's written consent. I have seen landlords take this down to 7 days. They don't want to authorize 14 days. So you need to point these certain clauses out to your clients and be asking them the question. And remember, the listing agent is the one that is generally filling out this rental agreement. But if you are representing a tenant, you need to understand the clauses as well so you can do a good review. One each over here. So
one important thing is that if the occupant is 18 and over, you have to name them. Otherwise, when you try to evict them, it's very difficult.
Yeah. So did you guys hear Peter? Can anybody tell me, can you hear him good?
Yes, 18 and over, you have to list them.
Okay, I just want to make sure the mic is picking him up because it'll be really critical during our discussion period after this.
Okay.
So the tenant has not paid, if the tenant has not paid all the amounts due, then the tenant has no right to possession or keys to the premises. Okay, so this agreement is voidable at the option of the provider if that's the case, and 2 calendar days after giving the tenant notice to pay. So it's kind of like a notice to perform, but if they came in and didn't give the cashier's check, just a pro tip, which people that do a lot of leases know this, you set the tenants up, or the lessee, we call them in commercial, but you always make sure that you're emailing to them the amount that they need to bring in cashier's check. You collect that when they're signing it. Collect that check, because you know, you won't have this problem. So you want to make sure that you're collecting when they're signing, okay? And then that check will be turned over to the property owner, and they will take that cashier's check and then execute the lease. So you can check A or B. It's either going to be a month to month or a lease that will terminate which date and at what time. So I will usually give them till, 7 or 8 p.m. to vacate the property on the lease date, because sometimes they're hiring movers. So make sure you're checking this. Okay. So the tenant agrees to pay. You put the amount here that they're going to pay per month for the term of this agreement. Remember, this is a 1-year lease. Even if you do it here, you could make it longer, but if there is going to be any increases, that will need to be handled in the body of the lease. But for now, they agree to pay this amount for the term of the lease. The rent is payable on the first day of each calendar month. Now, what if somebody was moving in on February 10th? For the property owner, please still collect 1 full month ahead with the security deposit. But it outlines it here. The following month, March, would be a prorated amount. So as a courtesy, let the tenant know you're collecting 1 full month, and then this will be in the amount. You need to put this in email to them that you'll be paying in March. We always want to come in with a full month. And it is calculated on 30 days per month, and it tells you right here. So when you do your prorations, it's always a 30-day month, okay? Payment. The rent, this initial rent that you're collecting shall be paid. I like cashier's checks at the initial. That is entirely up to the property owner, but for the initial payments, what I'm seeing is they're normally providing a cashier's check. You want to make sure you fill all this out, made payable to who, okay? And whatever is applicable, I haven't seen a lot of landlords, property owners, you have to correct myself, checking wire or electronic payment. But at any rate, discuss this with the property owner, check the appropriate box, make sure you put the name in there. So payment via electronic apps such as PayPal or Venmo, it's already embedded that is not accepted unless they check the box. Okay, so that's important to know. Rent shall be delivered to who? Maybe there's a different address where it's going to be or name. Maybe there's a property manager, but at any rate, put who it's going to be delivered to, whose phone number, and at what address. And if checked, the rent may be paid personally between hours. If there's an office, put the hours in here and what days that office would be open for a tenant to walk in and pay. Okay, so on number 3, D3, if the payment is returned for NSF, non-sufficient funds, or because the tenant stopped the payment, the housing provider may in writing require the tenant to pay rent in cash for 3 months and all future rent to be paid either a money order or a cashier's check. Again, I prefer a cashier's check. Okay, but that's up to the housing provider to tell you. So the rent payments received by the housing provider will always be applied to the earliest amount due or past due. Security deposit. Right here, the tenant agrees to pay the security deposit. It's telling you right here, the maximum amount of the security deposit paid, however designated, meaning don't think that you can get more because you're charging 100 for a key and 200 for a garage door opener. No, it has to be all inclusive, cannot exceed 1 month's rent unless an exception applies. I do have that form populated that they're referencing here, SDDA. I like the form. It explains very well about the deposit. So we'll go over that after we finish the lease. Security deposit is in addition to any advance payment of first month's rent. So Secure,
Aside from the security deposit, you can have an arrangement of advance rent.
yes.
But the rent has to be at least 6 months in
Ye-
order to qualify to the advance rent.
Yeah, and advance rent of not less than 6 months.
That's correct.
Okay, so that what Peter was mentioning is highlighted in 4B. So if you're going to collect advance rent, it cannot be less than 6 months advance rent. So security deposit, we don't hold any of the client's money in a broker's trust fund. This is a never for us. So you're always going to check transferred to and held by the owner of the premises. Remember, I know it's probably like I say it over and over, but we do not do any property management functions out of our brokerage. We do not have E&O insurance on that. We do not authorize agents to act in any manner as a property manager. So be careful, don't collect rent, don't take repair requests from tenants. Always direct them back to the property owner, okay?
And
So-
they don't pay enough.
Any of all portion of the security deposit can be used as reasonably necessary to cure a tenant's default in the rent, repair damage, excluding ordinary wear and tear caused by the tenant or by a guest of the tenant. So this is outlining here what it can be used for. It also has in bold that the security deposit shall not be used by the tenant in lieu of the last month's rent. Okay, and E, security deposits are not to be returned to the tenants until they have vacated the premises and all keys are returned. Any security deposit returned by check shall be made out to all of the tenants on the lease, not just one on this agreement, or as if they modified it during the term, okay? So F, there is no interest paid on the security deposit unless it was required by local law. Usually I've never seen any interest on them. Owners,
I also want to point out that the security deposit must be returned within 20 days after you vacate the premises.
very good.
And you have to have a clear calculations of what the security deposit is used for.
Okay. And so they need to provide a wrap up if they took money out of the tenant's deposit for any repair or things like that, they need to provide an explanation in writing how they use that money
Within 20 days.
within 20 days. Okay. So this is important. So move-in costs received/due. Again, move-in funds shall be paid by, discuss this with the property owner. So for me, I'll check cashier's check, okay? Because that's what the property owner told me. So the categories are here. So it's rent. So this would indicate that this is the first month's rent that you can collect when they're, signing this agreement, security deposit, and other. So it would be the dates of the first month here and the security deposit. You would put the total amount due here, the rent, the security deposit, balance due, due date payable to. Even though this agreement has the property owner's name on it, I always like to see the payable to here again. Put the name in, make it simple for people. Payment received. You can hand date this if they gave you a cashier's check, the property owner can certainly hand date that. You can give them back a copy of that, okay? But make sure this is filled out. It's going to calculate the total down here for you. So late charges and return checks. So here it defaults to if they have not received the rent within 5 calendar days after the due date, sometimes housing providers will amend this. Maybe they want it 3 days. So make sure as a listing agent that you're paying attention to these little things that you can really help the housing provider with you will get more business because you know this contract. So after the date, or let's see, tenant shall pay the housing provider, here's a percentage of the rent due. So if they are late, what percentage or sum will the housing provider charge as a late fee? So that's something you're going to need to be discussing with them. 5% perhaps, or whatever the housing provider tells you to insert here. It's either a sum or a percent. Now here you see that there's a $25 NSF fee. That probably is not enough to cover the amount of an NSF. I think the banks are higher now. 35. So if you want to amend this amount, make sure you are amending it in the back of the agreement. There is room to amend sections if you need to, okay? So housing provider agree that these amounts represent a fair and reasonable estimate. So up here, we're all in agreement. Parking, check A or B. Parking is permitted as follows. You check here, or parking is not permitted. There are some buildings that do not have parking, especially in very populated areas. So make sure you're checking one or the other. Parking is permitted as follows. It's either going to be assigned, attached garage, or maybe it's a first come, first serve parking lot. So make sure you're mentioning that here. You don't want to leave these blank because you don't want parking wars later among tenants. And if the property owner ever sold the building, you know, it's better to have the parking mapped out here. Please don't leave that blank. So the right to parking is included in the rent. Usually it's is or it is not. If not, if it wasn't included, how much are you charging them per month? Maybe in some highly populated areas, they're going to be charging for parking, but make sure you don't miss this section here if it is or is not included in the rent. Storage, same thing, check A or B. Storage is permitted as follows. Then you outline it here. The right to storage space is or is not included in the rent. Down here is the one I'm normally checking is B, except for the tenant's personal property contained entirely within the premises. Storage is not permitted on the premises. So it's generally going to be B, but maybe they have some storage closets. So you need to be talking to the property owner. On utilities, the tenant agrees to pay all utilities and services and the following charges. Right here, I usually write Wi-Fi, internet, comma, if desired. That is up to them, just to clue them in that maybe the building doesn't have that. And the housing provider certainly isn't going to pay for it, except so you can make an exception. If there's something that the property owner is paying, maybe they're paying the water. But anyway, makes the exception here if it's something they're going to pay. Okay, so if there's a lot to say about the utilities, you can write a separate addendum and attach it and check that here. So as agreed on a separate addendum, if any utilities are not separately metered, and they've made it really nice down here. If the property has a sub-meter for water, you need to check it. If the premise does not have separate gas meters, you need to check it. Electric meter. So the one that I normally see with the sub-meter is the water. So you do check it, and then there's a form WSM. The form is pretty intense because you need to give them, you know, the water company, the readers and all that. So if the tenant ever wants to check the accuracy of the reading, they know who to call, okay? So make sure that you know if anything's sub-metered or does not have a separate meter, okay? Some of your older properties may not have separate meters. You know, the newer ones, they're probably okay, all right? But always check. So the condition of the premises is saying that the tenant has examined the premises and if applicable, furniture, furnishings, appliances, landscaping, including smoke alarms and carbon monoxide detectors. So down here after that, it's saying to check all that apply, A, B, C, or other, D. I usually like A. It says the tenant's acknowledgement of the condition of these items is and contained in the attached statement of condition. So that is your move-in form. If you can get the tenant over there, 3 or 4 days prior to the lease, or signing, then go over there with them, take pictures, and have them fill out that move-in form. Check all the boxes, have them check. They can also submit pictures with it. So, or the housing provider will deliver this form, the move-in form, within 3 days after execution, prior to commencement date, etc. So the problem is sometimes you can wait and then they won't deliver it back to you. So I know it's contractually required, but I like getting it done on the top so I know I have it. With pictures, if it's something they really want to document, get the pictures too and print them. Maintenance and reporting, the tenant is responsible for any additional phone lines beyond 1 line and jack that the housing provider shall provide and maintain. Housing provider must maintain and provide 1 phone jack. And I just highlighted this because, you can't call the housing provider to put light bulbs in. The tenant is responsible for burned out light bulbs or mount and to replace them themselves. Okay. So B, 11B, the housing provider, tenant, or HOA shall water the garden, landscaping, trees, and shrubs except. So you need to check one of these boxes if that's applicable. So what could be an exception? Sometimes I've seen units where these are little locked patios and there's these tiny little shrub there. So maybe the gardener or the HOA can't get in to water the little shrub on the tiny little patio that is locked. So maybe they would want them to water those shrubs. That's the only exception that I have personally seen. So here on D, the housing provider or the tenant shall maintain. If there's something that one of those two need to maintain, make sure you're putting it here. We don't want things that are left unsaid or ambiguous. It's better to be as upfront on what the expectations are from each party, okay? So the tenant's failure to maintain any term for which they are responsible gives the housing provider the right to hire somebody and to charge the tenant back for the cost of the maintenance. Periodic pest control, housing provider or tenant. And this only applies to if the premises is a house and the periodic pest control treatment is being provided at the execution of this agreement. Normally for me, I'm not putting anything in here. So that you need to talk to the owner if it is a house. So the following items, people are always worried about warranty on items they leave in there. Because if they keep calling you to replace or fix a refrigerator or dishwasher, it can be a little frustrating. Right here in H, the following items of personal property are included without warranty, and the housing provider will not maintain or repair them. It's a great paragraph providing you put in here what that would be. Maybe it's a stove, refrigerator, dishwasher. So you want to make sure that you are highlighting that for the property owner and putting the appliances in. You don't want to get a bunch of calls to repair it.
Shall,
Yes.
I've seen that for years about the pest control for years, and it's right now. I just saw it in black and white. It's an option, either the landlord or the tenant. I never knew that.
Right.
It's in black and white.
And
right
it
there.
says
Yeah.
if it's a house, okay.
Yeah,
So
that's all pests, all rats, spiders.
yeah,
I mean,
usually if there's, the property providers that I've worked with, if
Right.
there's an infestation, they will protect their property,
of
right?
course, right.
So the tenant should still be reporting,
I know
but
about
yeah,
the tenant that
yeah,
don't let you in for one reason or the other.
yeah. Tenant, if this is applicable, understands that the the unit may be in a common interest development, and the housing provider may not have the authority or control over certain parts of the premises. So it's outlining maybe they don't control the roof, things like that, or shared parking structure or garage, okay? So neighborhood conditions, this is important. So the tenant needs to drive the neighborhood, satisfy themselves or herself as to the neighborhood or area conditions, including schools, proximity, and adequacy of law enforcement, things like that. They need to drive the neighborhood, know the neighborhood for themselves, okay? So I like this clause in the contract because it's giving them a heads up to go ahead and look. 13 is important. Animals, unless otherwise provided for in California Civil Code or other law, no animal shall be kept on or about the premises without the housing provider's prior written consent, or you check the box as agreed to in the attached animal terms and conditions agreement. So when people call you, and we will be having a broader discussion at the end of this and say, oh, do you take pets? That's different than a support animal or emotional support animal. So don't get caught up or a service animal, if they start getting real specific with you that it's an emotional support animal or service animal, sure, submit your application is your answer. You cannot say, no, we're not going to take your service animal. No. Pet is a different thing from service or emotional support.
Yeah, those service animals and the support animal are not pets by definition.
Yeah.
So it is needed by the tenants, and you cannot refuse categorically, not to happen.
Only based on that, right?
Right.
Yeah.
Right.
So don't answer the questions saying, oh, no, they don't want any animal or pet on the property if they're telling you it's a service or emotional support. So that's part of what we're going to talk to at the end, how to language and speak to people on leases. Smoking, no smoking of any substances allowed. It's already embedded in here unless they check the box. Smoking of the following substances are allowed in here. Most of the time, this is just left to default that no smoking, is allowed, okay? Rules and regulations, number 15A. So the tenant agrees to comply with all housing provider rules and regulations that are at any time posted on the premises or delivered to the tenant. So you don't have to be so hung up if you don't have something to give them right now. You can post your rules and regulations or mail it to them. So just make sure you're aware of that, or if applicable, you can check that the housing provider will provide the tenant with a copy of the rules and regulations within how many days, or the tenant has been provided with and acknowledges receipt of the rules and regulations. So that's really applicable for sure if it's in an HOA. There will be rules and regulations,
Yeah, very important.
even governing tenants. So you need to make sure that as a housing provider or their agent, that you let them know to pull those and to provide those with the tenant with the lease. I would check B and provide them right up top. So if this is checked, you're alerting them that it's in a planned unit development and you need to provide the HOA name, okay? So, and you need to check one here that the housing provider will provide the HOA rules in how many days, or the housing provider has provided them. So here is for the HOA. Make sure you're getting those up top because they should be able to review those. You want to give them to them as fast as possible, perhaps even before they sign the lease agreement. It's only fair they know the rules, okay? Alterations and repairs, unless otherwise specified by law and without the provider's prior written consent, tenant is not to make any repairs, alterations, improvement on or about the premises. If you do make an improvement, like I can tell you at my daughter's apartment, I made an improvement of installing a window air conditioning in her bedroom at college because it is so hot in there. Yes, now that will belong to the housing provider when I leave, okay? But so make sure that you're understanding this paragraph. Or the housing provider could tell me, restore it back to the way it was when you lease this unit. Either one is fine with me, okay? So make sure you understand that. Keys and locks. Tenant acknowledges that the tenant will receive. I wouldn't give them these prior to commencement date. No, I don't check that. I only want to give it to them once it's, you know, all executed and all of that, and the commencement date is ready to go, maybe a day ahead of time. So you just outline here what you're giving. 18B is easily overlooked, but extremely important. Have the locks been changed? Please don't miss that box. It's have or have not. Unfortunately, it kind of gets lost. So 18B, please make sure you're helping your property owner by checking the appropriate box after you talk to them. If the tenant changes any locks, they immediately need to deliver copies of the keys to the housing provider. Okay, so entry, if the landlord needs to, or excuse me, housing provider needs to go in due to an emergency, they can make notice. If a tenant agrees that the housing provider, broker, or interested person, if they're trying to lease the property, they agree that they may take photos of the premises, and those photos aren't controlled. Once they hit the internet, we cannot control them, okay? So the provider and tenant agree that 24-hour written notice will be sufficient time, except as follows: 48 hours when they come and conduct an inspection of the premises prior to tenant moving out. So at that type of inspection, it's a 48-hour notice. Okay. So if the housing provider has in writing informed the tenant that the premises is up for sale, the tenant will be notified orally to show the premises, and you need to fill out the CAR form NIC. Then for the next 120 days following the delivery of that NIC, this notice may be given orally to show the premises. So if you know it's coming up for sale, make sure you help the housing provider by pointing this out to provide the form. No written notice is required, and if the tenant orally agrees to let the service provider in. Okay. So if checked, the tenant authorizes the use of a key safe lockbox. That would be checked here to allow entry to the premises. I really don't like that. That is up to the housing provider, but most tenants may not like a key being hung somewhere to their unit with their stuff in there. So photograph and internet, it's telling you right here, you can read it in more detail, that they will take pictures. The brokers can't control when pictures are taken by people that are coming to view the unit, and that we do not have control over the internet once those are posted, okay? So it's even advising them if there's things, if pictures are being taken that are of value and you don't want them showing, to put those away, okay? So tenant acknowledges that prospective interested persons coming onto the premises, and this is what they're telling you, may take photographs, videos, or other images, and the broker cannot control that. So that's embedded in the lease so that they're aware. I haven't seen too much problem with this, but if it goes up for sale, it may be more of an issue. The tenant does authorize the owner to put a for sale or lease sign on the premises. You cannot sublease the unit, even the parking space or storage space, or assign it unless you have the written consent of the housing provider. So don't try to lease a garage and make a little rent off it, or a storage space. That's not allowed either. So this prohibition also applies to short-term. It defaults to this: vacation and transient rentals, such as, but not limited to those, through an Airbnb. So it's already telling you here, you cannot do an Airbnb unless the provider allows you. Any violation of this is a non-curable material breach of this agreement. So it's pretty serious. I think at that point you could start eviction,
Yeah.
correct?
Okay.
Yeah, okay. So if there are more than one tenant, each one shall be individually and completely responsible for the performance and obligations. So if there's roommate situations, young people sometimes do that for school, and one's not paying, the other party could be liable. So make sure you understand this if you're in that situation. So this is going over the possession, and if the housing provider is not able to deliver possession, the premises on commencement date, it shall be extended. You can read more into that if that is the case. Tenant or the tenant is already in possession, which, yeah, I don't know why they would be in possession, but anyway, the possession is deemed terminated when the tenant has returned all keys to the premises to the housing provider. The tenant does have some obligations upon vacating. They're going to leave the property as they found it, empty of all persons, debris. They put it right here. So if there was somebody staying there that wasn't on the lease, they need to deliver this unit vacant and surrender it vacant and clean and without their stuff being there. So if they do leave stuff, the housing provider can provide a notice and remove the debris. Okay, so this is what I was talking about earlier, any improvements made or caused by the tenant with or without the housing provider's consent do become the property of the housing provider. Upon termination, the housing provider may charge the tenant for restoration of the premises to the condition. So that brand new air conditioner I bought now belongs to the housing provider, okay? So make sure you understand that. I like this right to pre-move out inspection. So after receiving notice of termination, the tenant has a right to request that the inspection of the premises take place prior to termination. I think that's great for a tenant. And that gives them ample time if there's repairs that the housing provider would have required for them to go ahead and get that done. Breach of or termination. So the tenant would also be responsible for lost rent, commissions, things of that nature. I'm sorry. Temporary relocation is subject to local law, and tenant agrees upon demand of housing provider to temporarily vacate the premise for a reasonable period. And this allows for fumigation or other methods to control the pest. And right here, the tenant is entitled to a credit of rent equal to per diem rent for the period of time, okay? Damage to the premises. If it was totally destroyed, of course, the lease will not continue. I'll let you read that on your own. Insurance. Please make sure you're talking to the housing provider on this. Check the box for them. Most housing providers should require the tenant to obtain liability insurance. Please point this out, check the box, and put the amount here. This is important. You always want to, advise the housing provider that perhaps they should require liability insurance. Another important paragraph, number 30. I am so sorry, I've had a cough. Waterbed portable washers. Here, I'm always going to check no portable dishwasher or washing machine. Why? They throw water all over the place.
Yeah.
I've seen them used in college dorms. So I'm always going to check that. But here it's allowing, thank you, for the tenant to have a waterbed if they provide insurance for it. Well, we don't want a waterbed. So you need to, if you don't want a waterbed, you need to put that in the other terms and conditions, because this contract allows for them to have it if they provide insurance for it. A lot of property owners don't want a water bed and it's defaulted into here. So make sure that you fix that if your client doesn't want a water bed in their property. These notices are important. You need to put the addresses, the notices for the name and the address, housing provider, tenant estoppel. If the housing provider asks, it must be provided within 3 days after they ask for it. Tenant representation regarding occupants. So here I'm only going to say that all statements must be true and factual. And the housing provider requires that all occupants 18 years or older and emancipated minors to complete lease rental applications, okay? So there even is a clause in here that when an occupant on the premises becomes 18, you know, they need to let the housing provider know. Perhaps they'll get a credit application on them. Housing provider warrants that they are unaware of any notice of defaults, etc. on the property. Mediation, I'll let you read that here. Attorney fees, they're only asking for $1,000, probably not enough, but you talk to the housing provider, the prevailing party would have to pay $1,000 or whatever amount you put in here. So the prevailing party on a lawsuit, okay? So car form, the mold and dampness automatically populates, bed bugs. There's a Megan's Law database disclosure. We don't look it up for them, but you can point it out.
I want to point out that this lease agreement, it didn't provide the arbitration, only provide for the mediation.
Oh, yeah.
Mediation is okay. Mediation is not legally binding, and it's all up to the two parties whether they want to resolve the dispute or not. But the arbitration is a binding proceeding. In other words, the decision in the arbitration is final. It cannot be appealed.
Okay,
So I think it's better not to include the arbitration in this lease agreement.
okay, so don't, Peter believes it's better for you not to attach an arbitration agreement to this lease agreement.
Right.
I think you could all hear, I hope. So on D, I like to check this box. I want that residential environmental hazards booklet. I usually print a copy. I put it in the kitchen on the counter so they can readily see it, but I like to include it. Or when they come and sign with you, you hand it to them. I just like the information in it. I think it's helpful. So I include the booklet always. Flood hazard disclosure. Flooding has a potential to provide, cause damage. And there is a CAR form, TEHD, for additional information. If there are other material facts, they need to be stated here. Additional disclosures. The rental property owner disclosure shall be provided to the tenant. There's a lead-based paint, meth, periodic pest control contracts, if applicable, mold, asbestos, things like that. I'm gonna not go, there are service members, civil relief, that'll be on that SDDD form. I'll go into that more. Time is of the essence. Anything, all understandings are incorporated into this agreement. Agency, make sure this is filled out properly for both forms. If checked, the term of this agreement exceeds 1 year, you would check here. We require the agency's disclosure even if it's not exceeding 1 year. Okay, so make sure you're providing that anyway. Now, termination of agency is really important. We are on agency with our client until you need to check what is going to choose all that apply. Maybe you want to terminate your agency once you deliver the keys, or you do a tenant walkthrough, but make sure you're not leaving this blank. You do want to terminate your agency relationship when one of these things happen. Okay, so it could be upon tenant occupancy, but make sure you're looking at C and checking a box. Broker compensation.
What's the most common, Phil? This more
For me,
brokerage thing do?
I either do delivering the keys or tenant occupancy. Because I figure they have entrance and,
Okay.
Yeah, so once they can put their foot in on their own, I don't want to have an agency. Yeah. So broker compensation, it's outlining here that there's a form, the tenant's compensation. Don't forget to do the TRBC when you are representing a tenant. That needs to be signed prior to showing. The tenant, the other agent, the listing agent would be paid via contract. So the owner agreement to pay, tenant's broker, check this box if that is applicable. You should have been talking to the other agent to see what they think would be something that the housing provider would entertain. And remember, do not request more from the housing provider than you have on your representation form with the tenant. The fixed lease. So then if that's the case, then you fill this out. The fixed lease percent, or it's a dollar amount, or a month to month, or a dollar amount, okay? So make sure you're checking that if that's applicable. They have added a new box where you can take you have to check this, but you do need permission. Okay, you do need permission to have the cashier's check structured so that the tenant brings you your commission. I usually don't do that, but they have provided for it now in the contract. Notice of right to receive a foreign language translation. If there are certain languages that the tenant can't speak, primarily Spanish, Chinese, Korean, if they do not understand you, then the housing provider should provide a translated form with all the terms of the lease agreement for them, okay? And it's right there. So it's kind of interesting when I reread that again. Okay, there's different requirements, local requirements, and they may or may not apply to the property. Other attachments are going to be rent cap, tenant flood. Let's see, positive tenant reporting. That's that new form that we went over last week, TRPR, or bed bugs. These automatically populate. Okay, you are legally authorized signer. You need to fill out the entity box if you are other than an individual. If you had to get that form translated, you need to check the box here and what the language was that you had to have it translated to. The premises is being managed by the owner. So here, the only other thing, because we don't manage, it would be if they told you to put their property management company here and you would have that filled out, okay? So it's just giving us a little thing that we don't guarantee the condition of the premises, things of that nature in this box. I'll let you read that on your own. And here is the entity. If it happens to be an entity, make sure you're filling that out. This is important. I want to make sure I highlight this. If you have a guarantee here, you need to fill it out, okay? If there's a guarantee on this lease agreement, fill this out. A guarantor, print their name and such, and have them sign it, their address. If I have a guarantor, I always want that a wet signature. I really don't prefer that to be electronic. Please get a wet signature for your client. Okay, so I'm going to stop there because we're at the end, and we do want to have a discussion on handling applications when we have clients. Did you want me to start it?
Yeah, go ahead.
When you are taking applications, please lay the applications on the counter at the house and let everybody have an opportunity to take an application. We are not the property owner. We do not make their decisions. Please do not block a prospective tenant from seeing a property. Let them in, let them all have an application. You are here to collect the data and to provide it to the housing provider. If they call you and say, gee, I can't make it to the property, I forgot to take one, go ahead and email them an application. This does not hurt. This is what you should be doing. Let everybody see the property, give everybody an application. It will be up to the housing provider to review them. And if you are asking for packages, what is a package? It's an application, usually a copy of a government issued ID, proof of funds, things of that nature. If you are asking for a package, I recommend you put it on a sheet and put it next to the applications. You do not want to request something different from one party to the other. Everything you request needs to be the same with all parties, not different because this person or that person. Everybody is requested the same documents from the housing provider. We already went over, be careful about pets if they have emotional support, that kind of thing. You collect the application anyway. Anything else to add, Peter?
No, there's three main categories of discrimination. One is the disability, the racial, and the source of income. In the last year, we had 3 cases on those categories. And so you have to be very careful when you're renting the residential houses to the tenants. And make sure that you don't discriminate on them on the being a disabled person or on the race or the source of income. And also, as Michelle mentioned, the service animal and the support animals, you have to be very careful too. And I have seen some cases that they make a big deal out of that, and the house provider has a difficult time to defend, you know. So those people out there, I'm sorry to say that, but they are out to get you. So you have to be very careful in what you talk to them, what you show them, and what you require of them, you know.
Michelle, I have a question for Peter.
Go ahead.
If I'm as the owner, property provider, and you come and tell me I have a service animal, and I go, okay, I'll look at your application, I'll consider it. Can I, do you know if I could tell them, or I want to cover myself from liability if that service animal bites somebody?
Well, you can say that whether you have any insurance, but you cannot require them to.
That was my question
Yeah.
to you. I
You
cannot
cannot require
So
them.
what if that dog bites somebody on my property? I'm liable?
Well, depends, if it is inside your premises, inside the premises, and they're supposed to be liable.
But not in
But
the
it's outside.
in the common
In the
area.
common area, then you're liable. You're supposed to have liability insurance to cover that. That should be okay.
That was it. I guess that was my,
Yes.
inside the property,
Inside the block is their responsibility.
so I
So
can,
you have to make sure, you have to make a point to tell them that whatever that's inside, you have to get your general liability and also the content.
can I make them get that?
Yes.
Yes.
Oh, I could, good.
It's
good,
embedded in the lease.
Okay,
You
good.
check the box though.
Good, okay, that was
You have to
my,
check the box.
yeah, okay, thank you.
Yeah, see, these little pro tips are just that you have to really be looking at the agreement and checking the right boxes and don't miss them, especially that rekeyed thing. That is missed so often, and it's so important for the tenant to know whether it was rekeyed or not. But be
Because
careful.
Everybody's taking advantage of the service dog. It's happening a lot in the condominium. They're saying, well, it's a service dog, and it's not. And there already been cases where it's jumped on people and bit them, and then they when you let them in, they said they were service dogs. They weren't.
Emotional support, you mean?
Or whatever.
Yeah, 'cause
Yeah.
there's more documentation on a service dog than there is on an emotional support.
Yeah,
'Cause,
okay.
yeah, as I recall from
So I
a
could tell
class.
them, yes, I'll accept it, or the provider, but you gotta get liability for inside the premise.
Yeah.
As long as you check that box, you said.
Are there any questions on Zoom?
Service animal.
It's like guide dogs, you know, for the blind, yeah, blind, yeah. And, you know, you need to adapt to lead your way, those are guide dogs.
Yeah, then we can see if you are blind, you
Yeah,
know,
yeah,
first dog, then
Right,
what
right.
about the,
The service, the emotional
Emotional.
support animal, you have to have a certification that
proof
prove
from
that
city
the
or the?
tenant needs it to, for the
Oh.
emotional well-being.
Okay, but if I'm the landlord, I don't like any kind of animal in my, property. Okay, submit your application with the paperwork,
Yeah.
right? But I can still refuse them, right?
Not based on
Not
that.
based on the, yeah, not based on.
Or then I can just tell my agent, forget about it, no animal, doesn't matter what kind of.
No, you cannot do that.
No.
Don't say that, yeah. If you said that.
There you go. That's why earlier when we were
Brother.
talking, it
Yeah.
said,
On the company.
when people say, oh, do you allow pets? No. Oh, but I have a service animal. I meant, do you allow service animals? Sure, submit your application. Do not say no. Don't get
Right.
trapped up in this stuff.
Okay, then we can refuse them for another reason.
Oh,
Right,
exactly.
exactly.
Only if it's a valid reason.
Legitimate.
Illegitimate, yeah.
Any application, for choosing someone who are better financial,
Financially, yeah, financially, or the credible provider.
Okay.
Herman, to answer your question about the phone jack, is it required? Can you line it out? I don't think so. And you said, and your question, is it mandatory? Yes, they wouldn't have embedded that in the lease. The housing provider is supposed to have one operational phone jack in the property, in the premises. This is for emergencies probably. But to answer your question, I wouldn't recommend you line it out and try to take that requirement out. You know, the car attorneys are pretty astute at what they, embed in and make as a default in the contract. So I don't recommend you line that out. Most properties at any rate are going to have at least one phone jack.
Not mine. I started ripping them out. Seriously.
Oh.
I didn't know that.
So you can install it again.
Does anybody have any questions? Okay. Okay, so I am going to conclude the meeting. We just want you to be careful when you're talking to people. If you have a situation, please don't let it get too far down the line before you ask if you need help. We're here to help you, so make sure you're asking. If you need help on the contract, I'm good at that. Peter's here to answer your questions on how to language if you feel like you need to talk to somebody, okay? So don't be afraid, just, less is more. I don't talk a lot when I'm meeting tenants and showing property. I let them do the talking and I just listen, okay? So if there's no further questions, we're going to conclude this Friday training meeting. And it will be recorded. So thank you all for attending and I hope you have a great weekend.
Thank you, Michelle.
Thank you.
Thank you.
Thank you all.